This Legal Bite is brought to you by the Dental Services Network, supporting teams in dentistry. Many think of emojis as a fun way to communicate with family, friends and work colleagues. But emojis also have a dark side that can leave employers with a sad face. Hello, my name is Dr. Craig Cameron and I'm a Senior Lecturer in Corporations Law at Griffith University and Corporate Counsel for the Dental Services Network. In this Legal Bite, I cover the question, what are the legal issues with emojis in your workplace? So what is an emoji? An emoji is Japanese for picture character. It's a small digital image or icon used to express an idea or emotion in electronic communications, and there are various types, social media, email and SMS. So, emojis can be a combination of emoji and text, or can be a number of emojis. When combined, provides a meaning, an expression of an emotion or an idea. Because emojis have meaning, they have serious legal consequences. So what are some of the legal consequences that have been covered in recent case law? Well, there's an Australian case involving health. It's the Healthcare Complaints Commission and Brennan. A GP in that case was found guilty of professional misconduct by maintaining a sexual relationship with one of his patients. During that sexual relationship, there were a number of inappropriate text messages sent by the GP, which involved the use of emoji. In the New Zealand decision of the New Zealand Dental Association and the Advertising Standards Board, the Dental Association brought a complaint about Pepsi advertising on Facebook. Pepsi advertised cartoon emoji depicting each of the 20 members of the All Black Rugby Union team. Those emoji were included on Pepsi cans. People could download the emoji, but also collect the cans. The Dental Association argued that this advertising was targeted at children, and it also encouraged excessive consumption, given the collectible nature of the cans. The Dental Association was unsuccessful. In a case in the United States, a person was convicted of stalking by using this string of emoji when communicating with the victim. So, there's case law involving emoji. But you might be wondering, well, that's all very well and good, but how does this apply to the workplace? Well, important point to note. As an employer, you can be vicariously liable for a number of actions of your employees which occur during the course of employment. What vicarious liability means is that you as an employer stand in the shoes of the person who committed the act which led to a loss. So that loss can be claimed as compensation against you as the employer. So what are some of the potential legal issues with emoji, which are specific to the workplace? Well, we can start with stalking, assault and harassment, which can be a criminal offence as well as a civil or a compensation action. Here are some examples of emojis that could be used by themselves or in combination with text or other emoji. What about defamation? So there's a potential action by employers against an employee that might ventilate on social media. My workplace is, well, you get the picture. What about disciplinary action? So termination of employment or suspension or a warning against an employee who uses emoji in an inappropriate fashion. So on social media or email, a dental assistant, for example, ventilates that the dentist that they're assisting is the devil incarnate or a really, really angry person. Sexual harassment. So emoji that could be used to intimidate, humiliate or offend an employee. And finally, thinking about disability discrimination. The potential to use emoji to humiliate an employee on social media. So, emojis are no laughing matter and they can have serious legal consequences. What can you do as an employer to minimise the risk? Well, I suggest two things. Number one, ensure that your IT, sexual harassment, equal opportunity policies and procedures incorporate images. And you can use emoji as an example of an image. So in other words, images like emoji can be used in a way which might be discrimination, harassment, and assault and or defamation. Also, number two, back up your policies with appropriate education. You need to train your staff. Simply having the staff sign a document saying that they've read the policies and procedures doesn't mean they're appropriately educated. Tribunals and courts look favourably on employers who do conduct proper training, as according to the court or tribunal, that's considered reasonable steps to prevent these actions from occurring in the workplace. And it is typically a defence to an action made by one person against you on the basis of vicarious liability. So that's our legal bite for this week. For further information, go to the Dental Services Network website at www.dentalservicesnetwork.com.au.